of our country. This is about equal rights. This is about that independents have got the same rights as political parties. And it's also about enriching our democracy, the fabric of our democracy, and it's about fighting what is right. This is a constitutional court case. This is not political. This is constitutional. This is about justice. This is about right. And we've always approached this as a constructive force. We're not here to be able to want to delay elections. And that's why in our strategy, we've been very focused to be streamlined and asked the court to make judgments on two very important issues. The first thing is that independent candidates and political parties will receive equal protection according to the human rights of the Constitution. The second thing is that the barriers of entry is equal. It's unfair that political parties in the far past had to get 1,000 signatures to qualify, and now it's gone up from 9,000 to 14,000 signatures. And that equates to, if it takes just 5 minutes to go and register a person to be a signatory for an independent candidate, it will take 10 months for 6 people, 8 hours a day, just to get the barriers to entry, which we believe is unfair. And then the last thing is, which is One South Africa movement, which Mzuli can speak about, is vacancies. It's unfair that an independent candidate, if he dies or the position becomes vacant, that they do a recalculation, that the next person on the list comes into power and takes that seat. So I'm going to hand over to Mzuli just to give some general remarks about today and what her feelings are, and then I'll open for questions.
So today obviously is one step in a long journey of electoral reform. We are back at this court because there's this constitutional court that said that independent candidates should be allowed to participate in the national elections, and that was well over 2 years ago. And if you followed this process, you would have seen an extreme amount of delays from Parliament. Many civil society organizations as well as individuals had made the very same inputs that you're going to see at the court today have been made across in the National Assembly process and in the processes of the NCOP. So nothing here is new or novel. It's stuff that Parliament has been made aware of, as well as the Ministry of Home Affairs, but they've chosen not to adopt some of these changes. And again, this isn't about policy considerations or what our preference is. It actually comes down to constitutionality. So like Michael had mentioned, we're here because there's a number of constitutional issues which are represented by a number of different organizations. One South Africa is focusing on 2 elements. One being the signature requirement, which, as Michael has explained, imposes a significant barrier of entry to participate, which is obviously a violation of rights such as equality, but also the political rights of independent candidates to participate. And then the second one deals with vacancies, but actually it comes down to the fact that this new electoral system literally throws votes away. And not just 2, not just 3, but you can anticipate that hundreds of thousands, even millions, depending on the popularity of a specific independent candidate, will essentially count for nothing. It will be thrown away, discarded, and that is a serious, serious injustice. There's people who literally died for everyone to have an equal vote, but also for that vote to count equally in the composition of Parliament. And so we can't actually accept any political system that says that your vote, because it's towards an independent, counts less. So that's actually the essence of the constitutional argument when it comes to vacancies and the sort of technicalities around that specific issue.
Dr. Louis, regarding some of the amendments, particularly with the National Assembly, you're asking for the 50-50 split to be removed and for there to be 350 for regional and 50 for compensatory. Appreciating that could take some time for Parliament to remedy that defect that you are calling out. Could this mean that we could go to another election without independents actually participating in a manner which they see is fit for purpose?
Well, look, I mean, I think that's the arguments in front of the court. You know, we're asking that the split should be 350-50, and the reason for that is because our actuarial submissions to the court today that show that instead of independent candidates having to achieve 90,000 votes, instead of the 45,000 90,000 votes to get a seat in Parliament. The 350-50 makes it that the independent candidates and parties each have to only get 45,000 votes. So to me, as chairman of the Independent Candidates Association, I'm really struggling, because if an independent candidate comes to me and says they want to stand as an independent candidate, it's very difficult for me to encourage them to stand if they must get 90,000 votes. So we're asking the court to do a writing in clause to make a judgment, and if the Constitutional Court makes a judgment and a writing in, it's very easy that Parliament just goes back and amends the Act, and that could take 1 or 2 months.